test. 1, 2, 3, test.
456.
What's that?
I said 456.
Yes. 1, 2, 3, test, test, test.
State of Ohio versus Eric Lemasters, case number 24-CR-874. Defendant is present and represented by defense counsel William Watson. Previous date in this court, the defendant pled guilty to 2 felonies of the 5th degree, theft and receiving stolen property. We are here today for the sentencing in the matter.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Lemasters is a complicated individual, Your Honor. He's obviously very troubled. I believe that there are some mental health issues. I believe that there are some drug issues, and I think that was evident with his positive test when he was back here for the change of plea. Coupled with all of that, Your Honor, when he picked up this case and while this case was pending, while he was out, he's had housing problems. He's basically been living out of his car. Mr. Lemasters, Your Honor, has his problems, but I don't think he's an evil person, Your Honor. I don't think he's like that. He certainly has a history, and he has gone to prison in the past, but as of late, Your Honor, I think his biggest issue is just living day to day. I mean, living out of his car, getting the few dollars that he can, and in this case, no excuse, but he saw an opportunity. He saw a debit card, I believe, or a credit card, whatever, lying there. He took it, and he I believe, played the lottery, thinking that he was going to get that $1 million scratch off and all of his problems would be solved. Your Honor, he's got some problems, but I do think Mr. Lemasters has some redeeming qualities in that I think he can be a good, productive individual in society, but I think he needs focus. Obviously, number one, he's got to address his drug problems. I mean, he's not gonna get anywhere if he's gonna continue using drugs. And then secondly, I think he needs to address his mental health problems and his housing issues. And I think if we could get Mr. Lemasters on the right path addressing these issues, he's going to come out a better person in the end. I know this court has a lot of discretion this afternoon as to what it can do for sentencing. And I know based on his history, it would be easy for the court to just say, well, you know, we're going to give him X amount of time in prison and be done with it. And Mr. Lemasters will do his time, he'll get out, and unfortunately, those problems are still going to be there. Drug problem, mental health problem, and housing issues are still going to be waiting for him, no matter how much time this court gives him. I'm asking the court to please take some of these factors into consideration, give him a chance at community control with whatever strings the court wants to impose on it. Put the ball in Mr. Lemasters' court. Let him show the court that he is going to address his problems and he is going to try to be a better person. And if he doesn't, he knows he's got 24 months hanging over his head, Your Honor. But I'm asking the court to please take these factors into consideration. Thank you, Your Honor.
Mr. Masters, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Well, I just like to apologize for any communications that I had may said or misinterpreted what I said to you or anyone else. That's probably it.
Thank you.
Thank you.
Mr. Watson, anything else on behalf of the defense?
No, Your Honor.
Mr. Gretzky for the state of Ohio.
Your Honor, the state recommends a prison sentence in this case. First, in regards to the conduct here, which is finding a credit card, using it for a relatively small amount. Count 1, accounting for the actual taking of the credit card, and count 2, accounting for the use of the credit card at 2 different locations for a total of $150. It's been mentioned in this case that it was the fact that what was taken was a credit card that brought it to a level of a felony. And I just want to highlight the point that the reason that is because in the credit card and in someone's bank account is their livelihood. And in this case, and when the defendant was holding the credit card of the individual. He didn't know what the livelihood was. He didn't know what amount was on there. And in this case, it just so happened that that small amount that he used meant a great lot, a lot to the victim. It was an incredibly important amount, although it was seemingly relatively small amount. It was a lot for her, and it had a very lasting and compounding impact when he used it. Additionally, the defendant has served a prior prison term, and that was after multiple probation violations in the case. He violated bond by testing positive, and throughout the reports of his assessments with probation and with a substance abuse specialist, he showed a lack of commitment in addressing any of those issues. So for all of those reasons, the state is asking for prison.
This court reviewed the pre-sentence report and investigation, drug and alcohol evaluation, victim impact statement. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in open court by the defendant, his attorney, the prosecutor. All this is considered by this court in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, I will note, as the prosecutor alluded to, that while the amount of money itself wasn't a large amount of money, the impact that it had on the victim was significant. This victim, because that money was no longer in an account, wound up, I guess, for lack of a better word, bouncing several payments on other bills, on bills that she owed that didn't clear because that money was not in her account. She had payments set up to come out of her account, and when that money was gone, those payments bounced. She was assessed fees. She had to deal with the headache of all of that, and it had a significant impact on her, and that makes this more serious. There's nothing that makes it less serious. As for recidivism factors, almost all of these are present. The defendant has a history of criminal convictions. He has not responded favorably in the past to previously imposed sanctions. He has been on probation in this court before, where we gave a lot of treatment to him at that time. He violated his probation 3 separate occasions when he was on probation in this court in the past, ultimately being sentenced to serve a prison term. So he has not complied in the past with previously imposed sanctions ordered by this court. He violated the conditions of his bond by using drugs while on bond, which also shows he failed to comply with the orders and conditions of his bond. Don't know if there's a drug abuse problem that relates to the offense, but there's clearly a drug abuse problem that he denies. When he was here last time, he said he was sober for 10 years. And he didn't even need a drug and alcohol assessment. He was upset that his lawyer was asking for a drug and alcohol assessment because he's been sober for 10 years. And then he went right over to probation and tested positive for drugs. But he denies having any issues, denies needing any treatment. He said to the probation department, he doesn't need any services or treatment. He knows what to do, and was adamant that he would not take any medication if it was prescribed. He wasn't cooperative with the probation department when he was during this process. Other factors indicating recidivism is more likely is that while in jail here, has been disciplined multiple times in this short period of time that he's been in the jail for not complying with the rules in the jail. No factors indicate prison recidivism is less likely. Under 2913B1, court finds the defendant has previously served a prison term. Prison is consistent with the purpose and principles of the sentence, and there's no way the court can make a finding that the defendant would be amenable to community control sanctions. Therefore, it's a sentence of this court that on count 1 and 2, the defendant served a term in prison of 11 months on each count. I'll run those concurrent with each other for a total of 11 months in prison. His credit for 46 days he served. Need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves of the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Under restitution, the amount of $150. The defendant's ordered to pay all costs. And counts 3 and 4 are dismissed. Ms. Legretzky, is there anything else for the record?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right.
Shit. What about that lady that, on a statement that wrote that, Break this. Lady's fucking lifting that state up for child support, welfare, all that, for lottery tickets, if you read the statement, you know, Ron? Doing drugs, I see.
What's that? Which one?
We have one more, do we not?
Are you on Brady?
Don't bring it up. I'm still upset.
Do you have a recommendation for her?
Still community control. I committed to that, I think.
I'm not.
You did, as long as there weren't like major violations.
And she didn't get out.
No, she's been
It
in
appears that
county
way.
since. So, so I filed a motion to reinstate her bond.
Yeah.
I had, yeah, it was then so I had called Cuyahoga County. They did not have a warrant for it, but there are misdemeanors, like out of, I think, Garfield, Maple Heights for traffic stuff. There are warrants, so I believe that's why the judge denied it, because there's traffic warrants out there.
Actually, I'm out of this one. This is Jamie's report.
Okay.
This is Jamie's report.
Maybe it was the prosecutor you was yelling at.
Okay.
She didn't read it.
The lady that wrote the report, I don't think he was pointing to you.
After
No,
this
this
one.
is Jamie's.
Here in the case of State of Ohio versus Shaquilla Brady, case number 23 CR 840, defendant is present, represented by defense counsel William Watson. Previous date, the defendant pled guilty in court to tampering with evidence, felony of the 3rd degree, and 2 counts of possession of cocaine as felonies of the 5th degree. We are here today for the sentencing in the matter.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. I know we've had prior court hearings where some light has been shed on Ms. Brady in this case, and I know we had off-the-record discussions in chambers just now. But Your Honor, Ms. Brady is a woman she's a mother of 6 children. She certainly has some issues, specifically with anger management and maybe an attitude. That being said, Your Honor, I think over the past 2.5 months that she's been in our county jail, I've personally seen a change in Ms. Brady's demeanor and her way of thinking, for the positive, I might add. For this particular case, Your Honor, just for the record, at the time of this incident, she admittedly had a major drug problem. I believe she was very forthcoming with the pre-sentence report. She was charged. She did not show up to court. There was a warrant out for quite a long time. Now, I know that in and of itself would be a huge red flag for most courts, but in a little deference to Ms. Brady, during that time period, she in fact was going to Signature Health. She was doing something to address her drug addiction. Now, that wasn't specifically for the case. That was ultimately to keep her kids, her 6 children. Well, 5 at the time. There was one born just last year, Your Honor. But she was picked up on this case. I know she was been a little testy in court at prior hearings. But again, over the past 2.5 months, she's changed. She's reflected on who she is. She's reflected on her actions and her choices, not only just recently, but throughout her life. And she's told me, I've met with Ms. Brady numerous times. I've spoken with her on the phone numerous times, and she's told me that she is hyper-focused, that she wants to get her children back, that she wants to be the best mother that she can be. She has been sober for a little while now. I don't specifically know. Maybe Ms. Brady can shed some light on that. But because she was addressing her drug addiction through Signature Health, but she's told me, Ms. Brady's told me, if she were to get out, if she were granted community control, one of the first things she's going to do is go right back to Signature Health and pick up where she left off. She wants to continue working with them, continue with her sobriety, and to continue working on herself, her mental health, and everything else to, again, become a better person and to be a better mother to her children. Your Honor, she does not have a felony record. I know that there are numerous misdemeanors. I know there's some juvenile adjudications, but no felonies as an adult. I'm going to respectfully ask the court to consider a community control sanction with whatever strings the court wants to attach to it. I believe Ms. Brady is very sincere when she says that she wants to change as a person and she wants to be a better mother to her kids. And I think if the court will grant her an opportunity on community control, she's going to show the court that she can, in fact, be that individual. You're going to hear from her in just a minute, Your Honor. She wrote a nice letter to read to the court, but I'm hoping the court will take all these factors into consideration. Thank you, Your Honor.
Thank you. Well, Ms. Brady, you do have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead. Take your time.
I want to first give my apologies to the courts for not taking care of this sooner. I was in a very dark place at the time. I lost everything. I lost my children. I kind of lost my mind. I was dealing with the wrong people. But I have learned my lesson. That is not what I want for my life. That is not what I want for my children's life. I definitely want to be a fit, sober, and present mom to my children. I want to be a better mother for myself. And I was addressing my mental health through Signature Health doing AOD. I was also doing
AOD? What's that?
alcohol and drugs.
Okay.
And, I was doing the mental health with Sharvie. I had case management. I was starting grief classes because my mom's passing day is tomorrow. And then I have a daughter that passed away on March 3rd. So the beginning of the year is very hard for me. And it's easy for me to fall victim to drinking or whatever when these times come around. But I'm not going to do that anymore. I just want to be better for my children, for myself. I have obtained a home for us, so we don't have to be in anybody else's space. It's very comfortable. It's furnished. And things are really looking up for me. I'm working with University Settlement also to help with job skill building. And I just would really appreciate if you please let me just go home on community control to my kids so that I can get them back on track and my home back on track. I have a court date for the 17th for juvenile courts, and they would make a decision because I've been here so long about my children. And I just want to be present. I want to be better. And I just would appreciate if you please just give me a chance. I won't make a mockery of your court or myself. Yep. That's it. Thank you, Your Honor.
Thank you. Mr. Watson, anything else on behalf of the defense?
Nothing further, Your Honor.
Mr. Gretzky for the state of Ohio.
State recommends community control sanctions. Thank you.
Court reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered what's been said here in court today by the defendant herself, her lawyer, the prosecutor, the recommendations from the parties. Considered the particular facts and circumstances of the offense involved, the nature of the offense. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911 in the revised code. As for the factors in 2912, nothing stands out factually to this court indicating it's any more or less serious than what normally constitutes the commission of these offenses. As for the recidivism factors, court finds the offense was committed while the defendant was on bond, Cleveland Heights Municipal Court. That she has a history of criminal convictions. They're all misdemeanors. The ultimate convictions have all been misdemeanors. There have been some felony charges, but they've all been either dismissed or reduced to misdemeanors, so this is her first felony. But she does have a lengthy history of misdemeanor convictions. She has not responded favorably in the past to previously imposed sanctions ordered by different courts. The biggest issue that Ms. Brady has is that she doesn't go to court. There's 7 warrants issued for her right now for her failure to appear at different courts throughout Northeast Ohio, here in Cleveland, Cuyahoga. Yeah, you want to say something?
Yes. I'm sorry. I haven't been stable. I haven't had an address, and I really didn't know about the court system, and I wasn't addressing my mental health at those times. So I really do apologize, but that will never happen again. As soon as whatever you do with me, I'm going to go and handle all of those because I want to be better. I want to obtain my license, and I want to be better.
I appreciate that, but it still doesn't erase the fact that there's 7 warrants out there for you because you haven't shown up for court. Now, do you have reasons for that, perhaps? He also didn't show up in this case as well, which is a factor indicating recidivism is more likely. Drug abuse problem related to the offense. The defendant doesn't believe there's any issues now. Now, she has taken steps on her own to attempt to address this, but there's a lengthy history of drug abuse. No factors indicate recidivism is less likely. Under 2913B1, the court does find the defendant, again, did violate her bond and failing to appear for her court hearings, and it was gone for a long time before she was ultimately arrested. But that violation of bond is a factor that overrides the presumption for probation and permits the court to impose a prison term without having to make any special findings for that. Certainly based on that, the history with the defendant of just not appearing, prison's consistent with the purposes and principles of sentencing. But I'll give you one chance on probation to show you're sincere. Now, we're going to give you some treatment first, and you may not be happy about that, but you're going to get some treatment before you leave on your own. I'm not going to send you out there without that. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 130 days in jail. You have credit for 84. You are to immediately get into the jail treatment program and successfully complete that program. Follow all their aftercare recommendations. Further conditions then, you are not to use any drugs or alcohol. That includes marijuana, nothing with any prescription, marijuana prescription cards, no marijuana use, no drug use at all, no alcohol. Submit random urine screens when requested. They have to be negative. A positive screen will be a violation. To attend 3 AA meetings a week and have a sponsor. I want you to obtain employment. And continue with your mental health counseling, which includes, the grief counseling. It sounds like that's something that's certainly be beneficial. The parenting classes. And I also want you to deal with anger management counseling. You are also to resolve these warrants. However you resolve them, they resolve it. Nothing that happened in the past is going to violate your probation now. So you resolve those however you think you need to resolve those in your best interest. But they need to get resolved. They can't have you on probation with all these warrants issued. Pay court costs and supervision fees. The remaining counts of the indictment will be dismissed. You need to behave when you're in jail as well. If you keep getting disciplined in jail for issues, it's going to cause a problem. I omitted that and forgot to mention that when I was going through my factors, but there's been at least 4 disciplinary issues while you've been in the jail here. Ms. Randallson, is there anything else I should be thinking about here?
No, Your Honor.
So, Ms. Brad, you understand the conditions of your probation?
Yes, Your Honor.
You have any questions for me?
No, Your Honor.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you were to commit a new crime from this day forward. So again, whatever's pending out there, you resolve however you think's in your best interest. Nothing that has happened in the past is going to terminate your probation in this case as far as violation goes. You understand that?
Yes, Your Honor.
But if you commit some new act from this day forward that results in a conviction, anything like that should happen, a motion to terminate your probation will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you. Or I could terminate your probation and send you to prison. And if that were to happen, the prison term imposed would be a period of 36 months on count 1, 12 months on counts 2 and 3. Those would all be ordered to be served consecutive. So 5 years in prison is what's hanging over your head. You understand that?
Yes, Your Honor.
Mr. Mr. Watson, anything else for the record?
Nothing further, Your Honor.
Mr. Gretzky?
Your Honor, can the contraband and instrumentalities in this case be forfeited?
Yeah, that'll all be forfeited.
And I apologize, was it 130 or 134 days?
It's 130 days
Okay.
with 84 credit, so there should be 46 left. That's my math's right, yeah.
Thank you.
Mr. Watson, anything else?
Nothing further, Your Honor.
All rise.
This was some straight up bullshit.
Not that you're saying anything bad, I'm just
We're here in the case of State of Ohio versus Amanda Bowers, case number 24 CR 1207. Defendant is present, represented by defense counsel John Fatika. Defendant has pled guilty to 3 felonies of the 5th degree: possession of cocaine, possession of heroin, and possession of dangerous drugs. We are here today for the sentencing in the matter.
Thank you. Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of the client?
Yes, good afternoon. I've had an opportunity to review the PSR, the drug and alcohol evaluation. I'd like to highlight the fact that Ms. Bowers has made tremendous progress over the pendency of this case. Today is her 60th day sober. She tested negative on both of her urine screens. She's doing well at New Beginnings, making use of her peer support and her sponsor. As I look through the PSR, what jumps out, she's been struggling with substance use since the age of 12. I believe that she's dual diagnosis. She's finally being proactive and getting the help she needs. She's getting counseling through Signature Health and is in residential treatment. She's got 2 or 3 weeks left at New Beginnings, and then she has a bed available at the Jefferson Women's Sober House. As I said in chambers, I don't think there's anyone that Ms. Bowers has hurt more than herself. She's coming to grips with the fact that her children are 15 and 22. She hasn't had as active a role in their lives as she would have preferred. Doesn't have any violent prior convictions. And when I sat down with Ms. Bowers a couple of months ago, I said, look, what we're going to have to deal with is what's different now than in 2020. And I would respectfully suggest she's being proactive now. She's doing all the right things. She's on the right track. We're going to respectfully request the court consider imposing Lisa Friend's recommendations, let her finish New Beginnings, participate in sober living, attend 3 to 5 AA meetings a week, continue with her counseling at Signature Health. With the court's permission, Ms. Bowers' sponsor is here. I'd like to give her an opportunity to speak on her behalf.
We can hear from whoever. So whoever it is, you can just stand right there, state your full name and spell your last name for the court report, and then take your time and say whatever you'd like me to know.
Hi, Your Honor. My name's Amber Fulton, Fulton, and I am Amanda's sponsor. Over the past couple months that I've known Amanda, she's, making great strides. Of course, she's not perfect. She has a lot of work to do in this program, but she's taken the suggestions of AA, and she's really done a tremendous job with it. She participates regularly in meetings. She's very active in the program. She's with me at least 4 times a week in the meetings. And she's done the work that I've asked her to do with regards to the steps. She's completed step 3. She is currently working on step 4, which is a very long and involved step, so that will take her some time to complete. But she has listened to every direction that I have given her, and she has actively participated.
Great. Thank you so much.
You're welcome.
Anyone else, Mr. Fatika?
No, thank you, Your Honor.
Miss Bowers, I apologize. You have the right to address the court prior to sentencing. You can say anything you want. Is there anything you'd like to say at this time?
Do you understand?
Whatever you're comfortable doing.
Okay.
If you don't want to, I don't interpret that as any disrespect. If you're more comfortable.
I just want to state, what's different this time is my actual willingness. When as being an addict, you're in denial a lot of time, and I was in denial before. But my honesty and my willingness is what's changed, and I actually want to do this compared to where I want to be a mom. I want to change my life. I don't want to be doing drugs and damaging myself and hurting my friends. A lot of my mental issues had been a problem, but now I'm addressing those instead of just masking them with substances. I'd just like to say that on my behalf that there's no going back for me now. I made this decision. I dropped to my knees and I prayed to God, to help me, give me the courage to change. And, when I got pulled over, I literally thanked the cop because I thought I could stop at any time that I wanted to, and I didn't realize how
bad my addiction was and that I needed the help. So it was a process, but I put myself through detox a couple of days after being arrested and started Signature Health. But I would like to clarify, I did switch counselors from Signature Health. I'm at Community Care now because it's with New Beginnings, which is right in the same parking lot. But I started IOP already. And there's just a lot of things that I didn't understand before that I do now.
You must, at some point, it sounds like you must have used again, though, after the arrest.
So I went to detox, and when I got out of detox, I was still around the same people because I had nowhere to go. I thought, I'm strong. I can not use in front of these people. And unfortunately, no, you have to change your people, places, and things. So I had to cut everybody out. I tried to get a job. I said if I didn't get that job that day, I was going inpatient. And then my public defender called me and said, no, get into inpatient. So I did, and I chose New Beginnings because Lake County is a huge trigger for me. This is where I'm from, so it's nice to be. I'm so close, but it's nice that I have new people around me, people that haven't, judged me from things in the past. And I've never had so much support in my life for anything. Like, I'm always the one running to people. Like, what can I do for you? As soon as I told my peer support, who's in this room today, that I had court, she's like, oh, when? I'm coming. And I was like, wow, nobody's ever offered to do anything nice for me. So I feel the love and the support, and I don't want to lose that for anything these days.
So the 2-month sober date that he indicated is accurate?
Yes, November 15th.
So right before you went in?
I went in November 15th. Yeah, because it was unmanageable. My addiction became unmanageable. Had been unmanageable.
So I look at this, your history, and I guess the main question in my head, and I know you're trying to address it, but just in the past when you've been with me, there's a lot of treatment that you've been given, a lot of programs that you've gone through. Why is this one different this time?
So I did take something from each one of those treatment programs, like the Thinking for a Change in NeoCap and Change Your Thinking. What I did not take with me from those treatments is to follow through with my mental health. I thought when I was done with that, I graduated and everything was fine. But as soon as one issue came up in life, a boyfriend or something, I just went straight to using again and giving up on myself in my life, thinking the guilt, shame, and regret, I could never come back from that. So why try? Just keep digging the hole, until I saw my daughter, my 15-year-old daughter, walking down the road one day, and I got to get out of the car and give her a hug, and I hadn't seen her since she was 10. And she was so big, and she says, Mom, and she just loved me so much. And I'm like, what am I doing? Why am I? My kids are beautiful. My family's great. I can't.
When did
my
that
parents
happen?
did good. That was a week before I got arrested, and that was when I wanted to turn the page, and I was just praying to God, help me, give me the courage. It's hard to walk through those doors. My son, actually my 22-year-old son, came out from Lorraine, and him and my mother took me to Laurelwood, and I was still so scared to walk through, and he walked me in those doors, and he's autistic, and he wrote his number down, his name on a piece of paper, and gave it to the lady. He says, this is my number, and that's my mom, and you call me if anything happens to my mom. And my health wasn't good. So actually they sent me to the ER, so I damaged my body so much I wasn't breathing good. I was very, very sick. So I did go to Laurelwood on the 9/27, but they don't have me actually in there till 9/28 because they sent me to the emergency room, which is right over there. But then I thought so I went through the detox of the heroin, so I'm good now. But
What happened?
I just masked it. I just replaced. I did not realize that I was a replacer. You know, throughout my whole life, last time I said it was 17, I started using sticks when I got in trouble. But that's not true. Now I'm honest. It was when I was 12 I started getting drinking and smoking weed and stuff. And how can you overcome something if you're lying about it? So today I'm just trying to be as honest as I can to get the help that I need, so I can be an active part of my family, an active part of society again.
Was there anything else you'd like to say? You don't have to, just make sure you said everything you wanted to say.
No, I think that's it.
Sorry?
No, I think that's it. Thank
Right.
you.
Mr. Fatik, anything else on behalf of the client?
No, thank you, Your Honor.
Mr. Gretzky for the state of Ohio.
State recommends community control sanctions. Thank you.
This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation, have considered the facts and circumstances of the offenses involved, the nature of those offenses. Excuse me. Have considered everything that's been said here in court today by Ms. Bowers herself, her lawyer, her sponsor, the prosecutor, the recommendations. All of this is I also received numerous letters in support of the defendant that I read, and I've considered those. All of this is considered under the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, nothing stands out factually about the case to this court, indicating it's any more or less serious than what normally constitutes the commission of the offenses. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. She has previously served a prison term. She has not responded in the past favorably to previously imposed sanctions. She has been on probation in the court. There have been multiple violations that have been filed in the past. There's obviously a drug abuse problem that relates to the commission of the offense. Now I can't find, and I'm not going to find, that the defendant denies it or refuses treatment. She's done the opposite, actually. But that's a long-standing issue that has been out there and has continually caused her problems and been the root of the criminal conduct that she's been involved with. As for factors indicating recidivism is less likely, the court finds that there is genuine remorse and that the defendant has taken steps on her own prior to coming into court without being court ordered to do so to get herself into a program and appears to be doing well. Under 29-29-13b1, the court finds, again, the defendant previously served a prison term that overrides the presumption for probation. However, at this time, the court finds that prison would not be consistent with the purposes and principles of sentencing, and that the defendant is amenable to an available community control sanction. So, Ms. Bowers, I will give you the opportunity to continue what you started a couple months ago. And hopefully what you're saying is, you're sincere with what you're saying, and you're able to continue the progress that you've made.
Thank you.
The problem that, not no problem, I don't mean to use the word problem, but I guess an issue that there's that you've been with me before, and you've been on probation before, and I've given you multiple, last time you were on probation, I think you violated 3 times before I finally sent you to prison. So you're not going to have that leeway and that long leash this time. I mean, you appear very genuine, you appear sincere, you're doing it on your own so far. I mean, but if we're back here soon again, and it's not gonna come across as sincere then, you understand that?
Yes, I do understand.
So, I'm gonna give you a chance to continue what you started. I'm gonna put you on community control sanctions for 2 years. I'm gonna order that you serve 2 days in jail. You have credit for 2 days that you've already served, so there's no additional jail time. I'm gonna order that you continue and successfully complete the residential treatment program at New Beginnings. Follow all of their aftercare recommendations. I'm gonna order that upon completion of that you reside in a sober living residence for a minimum of 6 months. You can do it longer if you want, but at least 6 months. You are to continue with the medically assisted treatment that you're engaging in. You are not to use any drugs or alcohol. You must submit random urine screens when requested. They have to be negative. A positive screen's a violation. You can't screw around with or tamper with the urine sample in any way or bring in fake urine or someone else's urine, anything like that. That's actually worse to me than testing positive, quite frankly. You're to attend 3 to 5 AA meetings a week. Have a sponsor. Continue with your sponsor. At some point when you get through this, you're to obtain and maintain employment, full-time employment. Pay your court costs and supervision fees. Continue with your mental health services. Follow their recommendations. Take any medications as prescribed. You only have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine as well. But probation needs to know who the doctors are that give you prescriptions. You can only get them from those particular doctors. If you get a prescription from some other doctor that they don't know about, that'd be a violation.
Okay.
So if there's a new doctor that comes in the beginning, just make sure you let them know that. Sign whatever releases they need in order to contact them if that's necessary. You also can get your prescriptions filled at one pharmacy, so they need to know where that is as well. All right?
Okay.
Mr. Reynolds, is there anything else I should be thinking about here?
No, Your Honor.
So, Ms. Bowers, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Do you have
I
any questions for me?
No, not at this time.
I do need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another new offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions, which could include local jail time. Or at that point, I could terminate your probation and send you to prison. If I did that at that point, it would be 12 months on counts 1, 2, and 3. Each of those would be served consecutive. So it's 3 years of prison that's hanging over your head. You understand that?
I understand that.
Okay.
Yes, Your Honor.
I will also order the forfeiture of the contraband and instrumentalities that are set forth in the specification. I think that covers everything. Ms. Zagreski, am I missing anything, or is there anything else you care to discuss?
No, Your Honor.
Mr. Patika.
No, thank you, Your Honor.
All right. Good luck, Ms. Bowers.
Thank you.
All rise.
before you this afternoon is case number 24CR1103, captioned State of Ohio versus Quintel H. Simpson. Your Honor, the case was last before the court on December 17th of 2024. At that time, the defendant pled guilty to one count of gross sexual imposition of felony of the fourth degree in violation of ORC 290705A5. At the time, a pre-sentence investigation and victim impact statement were ordered. It's the state's understanding that those reports were submitted to the court for review. The defendant is present today in court with counsel, Mr. Matthews. We are here for purposes of sentence. The defendant does have, according to the Lake County Adult Probation Department, 128 days of jail time.
120 what?
8 days of jail time credit. And for the record, Judge, the victim's mother is present in the courtroom but does not wish to address the court beyond what is in the victim impact
Yeah, I
statement.
got statements from both her and the victim herself. All right, well, before we proceed with the sentencing hearing, I am going to and required to advise Mr. Simpson of what his obligations and duties will be to register as a sex offender in regards to this case. I know there's other responsibilities that he already has in that regard, but he will be required to do that in this case as a result of this case as well. So I'm going to advise you of that at this time. I'm going to read this form to you, which will tell you everything that you're required to do. When I'm done reading it to you, I'm going to have you sign it. Your signature is simply acknowledging that I did read it to you and you understand it. You don't necessarily, it doesn't necessarily say you agree with everything, but it just acknowledges I read it to you and you understand what the requirements are. So I'm going to do that at this time. You have pled guilty to a sexually oriented offense, and you are hereby classified as a Tier 3 sex offender. You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you are temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you've been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you're also required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or for an aggregate or overall total of 14 days in a calendar year. Employment also does include volunteer services. Now, you will be required to provide to the sheriff any temporary lodging information, including your address and length of stay, if your absence will be for 7 days or more. After the date of your initial registration, you will be required to periodically verify your residence address, place of employment, and or place of education, if any of that's applicable, in person at the county sheriff's office no earlier than 10 days prior to your verification date. Now, if you change your residence address, place of employment, and or place of education, if that's applicable, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after you've changed your employment. If the residence address change is not to a fixed address, you will include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register that fixed address with the sheriff of the county where that address is located. Now, you are further advised that in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall also provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers that are registered to you or used by you to the sheriff with the most recently registered. Now, these requirements I just explained to you, since you're a Tier 3 offender, you'll be required to comply with them for the rest of your life with in-person verification occurring every 90 days. Now, since you're, well, I should ask you this. Let me back up for 1 second. I want to verify some information to make sure we have everything correctly. Your full name is Quintel, middle initial I have Henry Alexander, and then Simpson.
Correct.
Social Security number is 299-767534.
Correct.
Do you have an expected address that you intend on residing at upon any release from any incarceration?
At this point in time, no.
Okay. That's fine if you don't know at this point. Do you have a phone number, cell, home number, any type of phones that you use?
Cell phone,
What is that number?
216
Okay,
393
okay,
3510.
okay. Now, since your expected residence address at this point is unknown, I can't give you specific information or address where you're to register, but I need to advise you that, again, you will have to register in person no later than 3 days after release from an incarceration with the county sheriff's office that is the sheriff's department for the county that you will be residing in. You understand that? If it's here in Lake County, it's the same one that you've been going to over on, is it South State or North State? North State Street, 84 North State Street in Painesville, if it's Lake County. If it's another county, then you're going to have to go to that sheriff's department. You understand that?
Understand.
Now, your failure to register, failure to verify residence at the specified times, or your failure to provide notice of a change in residence address or other required information, as I just described to you, will result in additional criminal prosecution. You understand that?
Yes.
Well, do you have any questions at all regarding these obligations and duties that I just advised you of?
No, sir.
You understand them all?
Yes, sir.
Okay. Then I am going to have you sign this form. It's printing out right now. Bailiff will hand it to you. On line 11 it reads, I acknowledge that the above requirements have been explained to me, and then I must abide by all the provisions of the Ohio Revised Code, Chapter 2950, which is the section that sets forth all these rules. So I'm going to ask that you sign line 11 right now. Again, that's just acknowledging that I read them to you and you understand them. Today's date is already placed in that spot, 1/13/2025. Line 11. All right, so I've been handed this form, Mr. Simpson, and it appears you signed it. Did you in fact sign it?
Yes.
All right, on line 12 it reads, I certify that I specifically informed the offender of his duties as set forth above, and that he indicated to me an understanding of those duties. I am going to sign that at this point as the judge here in Lake County that's presiding over this case. So, Mr. Shadow, I'll give this back to you. If you can make some copies. What do we need? 1, 2, 3, 4 copies, and then that's the original. So 4 copies. Mr. Simpson, you'll be given a copy of that before you leave here today. All right, with that matter being addressed, Mr. Matthews, is there any reason not to proceed to sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank
Go
you.
ahead.
Your Honor, we are asking for community control for Mr. Simpson. Aside from his convictions in 1999 that led to his current registration status, he has been relatively crime-free. There was a failure to notify change of address in 2010. He does not have any recollection of ever having failed to notify anyone, but the penalty was time served in jail and no probation. So I would like to think that it was not an active attempt to deceive anyone when that occurred. He does not currently have anywhere to live. He has been working with a representative of Signature Health in the jail. First name is Bree. That is all the information that I have. But Bree has been working with him to find some kind of permanent residence, and he indicates that she was going to attempt to contact him prior to today with an update on that, but that did not occur. So what we would ask the court to consider would be some additional time in local jail in order for those arrangements to be made so that Mr. Simpson would have somewhere to reside. He has a difficult time working. It's not impossible that he may be able to get on some kind of disability, but that avenue has not yet been pursued. But he has expressed remorse and a desire to seek counseling for these behaviors, Your Honor, and with that, we would ask the court consider community control.
Thank you. Mr. Simpson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, I am remorseful for what I have done to Sharita's daughter. I do, and I am willing to seek counseling to get help for not only what I have done, but also for what has happened to me as a kid during my 12 years in the system in foster care. I just ask you that you give me this chance so I can just get myself together, get the help that I need that I wasn't able to get then. If that makes sense.
Thank you, sir. Mr. Matthews, anything else you'd like this court to consider?
No, Your Honor.
Ms. Dorota for the state of Ohio.
Thank you, Judge. Judge, a review of defendant's record and application of the factors, in particular those set forth in 292912B, those that make it more serious, suggest that the defendant is not amenable to community control sanctions, and as a result of that, Judge, the state would ask that a prison sentence in this matter be imposed, the amount of prison to be determined by the court.
Thank you. This court did review the pre-sentence report and investigation. I received victim impact statement. I've read that. I've considered the particular facts and circumstances of the underlying offense, the nature of the offense. I've considered everything said here in court today by Mr. Matthews, the defendant himself, the prosecutor, and the recommendations from the parties. All of this is considered in light of the purposes and principles of felony sentencing set forth in 292911. As for the factors in 292912, the court notes factors indicating it's more serious is that the defendant's relationship with this victim facilitated the commission of the offense, and that the injury that she suffered as a result was exacerbated due to the mental condition of the victim at the time. No factors indicate the recidivism is, that the offense is less serious. As for recidivism factors, the court will note that there is a history of criminal convictions, but most notably, there's a conviction for the exact same thing that happened here. Defendant has a prior sex offense conviction. The conduct involved is very similar to the conduct that occurred in this particular matter. He has not responded favorably in the past to previously imposed sanctions. He did previously serve a prison term. He's on parole after that. He violated parole on a couple occasions. So that's a factor indicating recidivism is more likely. Court also notes that while in jail in lieu of bond, there are multiple instances of disciplinary matters that occurred which resulted in disciplinary issues, at least 1, 2, 3, 4, 5, 6 separate incidents while in jail that he was disciplined for over the course of the 2 months here. As for factors indicating recidivism is less likely, the court will note that the defendant did lead a law-abiding life for a significant number of years here. The conviction for that I referenced earlier was back in 2000, 1999, quite frankly. He was released from prison, I think, in 2001. The failure to notify of a change of address occurred in 2010, and there's been nothing since then. So I will note that for the record. Under 292913B1, the court finds that this is a sex offense, and that the defendant previously has served a prison term. Those are factors overriding any presumption for community control. The problem here is that we are here for identical conduct that the defendant has previously been convicted of and been in prison for, and he's again engaged in this conduct. The court finds that the conduct involved warrants a prison term. Prison's consistent with the purposes and principles of sentencing, and I can't find the defendant's amenable to available community control sanctions. Therefore, it's a sentence to this court that in count 1, defendant served a term in prison of 17 months. He has credit for 128 days he's already served. I need to advise you upon your release, you will be placed on post-release control for 5 years. If you violate any of those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% of the maximum term I impose. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The defendant's ordered to pay off costs incurred in this action. Mr. Road, is there anything else for the record at this point?
Nothing further, Judge.
Mr. Matthews?
No, Your Honor, thank you.
All rise.